This is the House Judiciary Non Civil Committee. It's late in the session, and I appreciate members' attendance and attention and focus. Also, which I clearly have right now. It's a process. The chair would also like to go ahead and take a brief time out and welcome Henry Ballinger to the committee this afternoon. It's unsettled as of now as to whether or not Mr. Ballinger will be exercising a proxy for Representative Ballinger, but I think he could do a pretty good job. Representative Ballinger has not confirmed that. Or denied. All right. Let's get right into it. Let's start out with Senate Bill 125. I know Senator Jeffries is chairing. Representative Kelly is the House sponsor on Senate Bill 125. Representative Kelly, welcome. Come to the table and be comfortable.
Thank you, Mr. Chairman. Senator Jeffries sent me here for two reasons. One, he is chairing the Senate Regulated Industries Committee, and second, because he didn't want Henry to be the youngest person here anymore. I'm here with Senate Bill 125, working off LC number 372433S. And the basic premise of this bill would allow our physician's assistants and our nurse practitioners in our state to have the authority, once given to them by a doctor, to prescribe a one-time, non-refillable, 5-day prescription of hydrocodone for adults. That will be limited to 30 tablets or 300 milligrams. But listening to the concerns of so many on this committee, we have restricted it even further for pediatrics, and it'll be the lesser of 30 pills or 100 milligrams. We've tried to be sensitive to listening to the concerns that members have had regarding an expansion of hydrocodone prescribing ability here, and I want to thank Madam Chair Cooper for her input. I think she certainly helped make this a better bill, and I appreciate that, and the work of Chairman Setzler, and of course you, Mr. Chairman. I'll be glad to answer any questions.
Thank you, Mr. Kelly. I'll turn it right over to the subcommittee chair, Chairman Setzler, for his report. Mr. Setzler.
Thank you, Mr. Chairman. I'd like to thank all the folks who were involved in this. This was a multifaceted effort, as these things often are. And the underlying concern about expanding access in a limited way for hydrocodone for people in rural Georgia was really the wind in the sail that got this thing done. Specifically, I think Representative Kelly highlighted the points. If it pleases the chair, I could highlight a couple policy points that changed in subcommittee, or I just wanted to know what level of detail you wanted me to go to. Again, as Representative Kelly talked about, there was concern in subcommittee about expanding dramatically the number of prescribers. Currently, the physicians in Georgia who can do this, there's 8,000 physicians roughly in Georgia who can prescribe. The PAs brought the bill initially to expand to another 3,500 prescribers. And then with the APRNs being added in, that was another roughly 4,500. So we've added 9,000 potential prescribers with the interest of providing access to really the smaller communities in Georgia. And that was a big policy question, but one that we felt like with all the testimony we got was adequately controlled and also sufficiently important to address that we just couldn't ignore that. That even though it was initially a PA bill, the idea that some communities don't have PA access but require a nurse practitioner to really provide the access to care that's needed for some of these serious injuries, that was persuasive in the subcommittee, Mr. Chairman. So adding nurse practitioners was really kind of the big muscle move in our subcommittee. In doing that, Representative Kelly spoke to the specific limitations, which is consistent with what a 5-day prescription could be, either in tablet form or in a syrup or in an IV drip. That was really worked out. And then also the proviso that because nurse practitioners come in with less training than PAs do, but the nurse practitioners who are into their career are very experienced and have the ability to do this, there was a proviso added that nurse practitioners have 36 months of clinical experience in their specialty area to be able to prescribe hydrocodone. That covers most nurse practitioners. Younger ones, just leaving school wouldn't be able to prescribe hydrocodone. But that was, again, a protection that really allowed the experienced nurse practitioners to provide the kind of access to care we thought was important. And then lastly, Mr. Chairman, there was a provision in Section 2 that speaks to that with respect to prescribing hydrocodone and really their prescriptive authority, the Composite Board of Medical Examiners, the State Medical Board, which oversees doctors and PAs, would have authority with respect to nurse practitioners' prescription authority, not their licensure, but prescription authority, if they acted out of step with their delegated authority in ways that wasn't in keeping with what would be expected, that the Composite Medical Board would have some influence over their ability to continue to prescribe. That was another balance to make sure that this act, which has historically been limited, and for the last 3 years, as we know, has been only the province of physicians, to the extent we're extending that to nurse practitioners, that the state composite board have influence over their ability to prescribe. So that was a balance that I think, and I certainly hope, strikes the balance that we need here among all the parties.
Thank you, Mr. Setzler. I think that the key word on that is balance. And I want to reiterate what Mr. Kelly said, and of course what Chairman Setzler said. This is exactly the way the legislative process is supposed to work. There may be threshold disagreements on the underlying policy, and that'll prove itself out when we get to a motion. But when you have people from different camps who are coming together in a collaborative effort, and I'm going to call on Mrs. Cooper in a minute to speak to that, and coming to what I'll call a practical solution, but with proper safeguards, straight-face safeguards, that can be worked on in years to come, but you start from an underlying foundation of erring on the side of caution. I think we do well by citizens, especially in the rural areas, because of a recognition that this matters. And it's not just in the rural areas, but of course it's going to have more of a pronounced effect, just from a practical standpoint, in the rural areas. And some of us in Metro Atlanta sometimes could easily forget about that if we're not reminded of it. But then we work in the practical safeguards that I think are in the bill that we seem to have struck agreement on, and it ends up being potentially very good policy.
And Mr. Chairman, I might just add one other quick
Sure.
thing that, again, the thing I think that moved the subcommittee was not what other states do or what we've done in the past, but that there is a real need in a urgent care setting to give people 5 days prescription until they can see a physician if it's a very serious condition. It was this sense that there are urgent, critical, emergent needs that, in spite of our concern to try to limit prescription of opioids, that urgent need, this 5-day bridge, was in fact something we couldn't ignore.
Thank you. Mrs. Cooper.
Thank you, Mr. Chairman. I feel like I'm sitting in a hole, but anyway, thank you for this time. I hope that if PAs and nurse practitioners are allowed this ability to order hydrocodone, which is the most abused drug we have in the nation. Americans use 96% of all the hydrocodone produced in the world. And to bring this home and to put you what we're doing in perspective, if each nurse practitioner and PA orders one prescription a day of hydrocodone, 5 days a week, not even 7 days, that will be approximately 2.2 million more prescriptions of hydrocodone ordered a year. One prescription for the 9,000 people that are going to be able to prescribe it 5 days a week comes out to 2.2 million prescriptions. And we are in a major opioid crisis. You know, I appreciate the chairman and the work that those of us that are listening to my concerns about it. I'm probably going to abstain from the vote because I still have a problem with the overall problem we have with a major opioid crisis in this country. This is something new. I'm sure there are some other states that would like to, you know, who have given this ability many years ago that maybe might like to change that until they can get this crisis under control. But I think we have come to at least a much better bill than what was originally out there. I hope that the PAs and nurse practitioners will see this to give a more of an emergency situation than just, giving it for convenience, that even with the ability that they may, like we are trying to encourage doctors to do, begin to say no, try, something less, try something much less. The other problem I have too is that with children, I would have much preferred to see us not give opiates to children. Even children from good homes, where the kids are talked to about drugs, where there's less likely, they have two parents, they're less likely to get involved in drugs and all. If they have an opioid prescription by the time they're in the 12th grade, they are 33% more likely to abuse drugs. This is a problem. Here again, I thank everybody for working with me on this issue to come to what I consider much better compromise, but I hope everybody will look at this very seriously because we have a major problem. So thank you, Trey, for working with me, and the chairman and Ed and everybody for working with it. But I couldn't in good conscience not, put that out there. Thank you.
Mr. Setzler.
Thank you, Mr. Chairman. One thing that was done, I wanted to highlight for folks on lines 48 through 50 to address Chairman Cooper's concern that the state medical board shall require each advanced practice registered nurse to have a unique number that will allow their prescribing to be tracked separately, as opposed to rolling up under their doc's DEA number, so that you've got, as PAs do now, and we're not prescribing how that happens, but there be a practitioner by practitioner tracking mechanism here. There had been some discussion about putting a mandatory reporting requirement by the composite board to our committees. That's not in the substitute, but there is a component here where a prescriber number will be designated for each APRN, so that we've got the kind of resolution to track by practitioner their prescribing habits in case there's some outliers, Mr. Chairman.
Thank you, Ms. Silcox.
Yes, I just wanted to express my concern with this bill also. I appreciate the collaborative nature of the compromise that's been reached, but at the same time, I do have to say that I got a number of emails from physicians that were very concerned about this. I'll just quote from one. As a rural urologist, I frequently encounter the confused nurse practitioner or physician's assistant who is unclear as to the cause of the patient's symptoms. It says, of course, one of the basic tenets of medicine is diagnosis before treatment. I know that the street value of these pills are $25 to $50 a pop, and I think if somebody's coming in for an emergency, they could be given a narcotic there without necessarily taking it home. But I think you're inviting these people to sell the balance of these drugs on the street, and I do think that physicians are best suited. They're trained and boarded physicians that should be giving these narcotics out. I know my husband is a physician. He's an orthopedic surgeon with Peachtree Orthopedic Clinic here in Atlanta, and he's the first to say that his PA is more generous, is quicker to give narcotics out than he is. So I just say that as a point of caution. Again, I just have my reservations about this bill.
Thank you. Dr. Price.
Thank you, Mr. Chairman. I'd like to echo the sentiments of Representative Silcox and Chairman Cooper. I believe that expanding access to a known highly addictive drug causing huge problems in our country right now is not wise. The abuse potential for this drug is significant. And the other point is the masking of symptoms by administering drugs when the diagnosis may not be correct. I think these are really significant concerns. I've also received a number of correspondences that don't indicate that we're resolving a problem, and in my opinion, we would be contributing to a known problem that I think we would have to have that on our consciences, that we would be contributing to the potential of over 2 million more prescriptions out there. So I would not be in favor of this. I know Chairman Cooper says she will abstain, but I will vote against it.
Questions for the House sponsor from members of the committee? Questions for the House sponsor? Seeing none, what's the pleasure of the committee?
Move due pass.
Mr. Reeves moves due pass of Senate Bill 125 by substitute LC 372433S, second by Mr. Trammell. Are there any amendments? Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the motion, of the gentleman's motion signify by saying aye.
Aye.
Opposed? The ayes clearly have it and the motion is adopted.
Thank you, Mr. Chairman.
Thank you,
Members
Mr.
of the
Kelly.
committee.
Senator Walker. Yeah, I'm calling you.
Thank you, Mr. Chairman and members of the committee. I'm here to present to you Senate Bill 45. This is the upskirting bill that you all have heard a lot about already. Representative Blackman and I both represent Houston County, and we had a grocery store clerk in Houston County at a Publix following a lady through the store and surreptitiously taking pictures up her skirt with his cell phone. That activity was captured on the security camera video. He was convicted, and later the conviction was overturned because Georgia law is not clear about your expectation of privacy in a public place. So Representative Blackman and I have been working together to try to close that loophole in the law. And his bill is HB 9. Mine is SB 45, and I'm working off of LC 297543S. I hope that's what you all have in your folder. Representative Blackman and I have gotten input from both this Judiciary Committee and the Senate Judiciary Committee, and we have changed our bills to make them identical. So HB 9 and SB 45 are identical proposals now. I can go through this, Mr. Chairman, if you'd like. Line 12 is a definition for device, line 12 through 15. Line 16 is a definition of intimate parts that reference another code section where the definition of intimate parts is in. Line 17 through 23 basically make it clear that you have that this type of activity is illegal. And then line 24 and 25 also makes it illegal to disseminate such videos if you know they were taken, or pictures or whatever, if you know they were taken in violation of line 16 through 23. Lines, I guess it's 26 through 29 set forth the punishment. And then we have lines 30 through 36, which we were real careful to craft the exceptions to this for law enforcement and businesses that in the ordinary course of their business use video surveillance to detect unlawful activity. Interestingly enough, this case got a pretty good bit of press, and we had the Morgan County Youth Assembly actually, which is the YMCA program. They actually, a young lady from Morgan County High School introduced a bill in the Senate Youth Assembly and got it passed and signed into law, and she testified at our Senate Judiciary hearing. She was very impressive. Be happy to answer any questions if you have any. and ask for your favorable consideration.
Mr. Reeves.
Thank you, Senator Walker. And just, I was going to speak to this as the identical bill that Representative Blackman carried that Senator Walker referred to did come through the committee that I'm the subcommittee that I'm the chairman of. And although it was, I guess, probably only 6 or 7 weeks ago, it feels like it was years ago that we were at that point. But this bill and this concept received a great deal of working out and massaging in our committee, and really we dove down and I believe perfected this concept and got it exactly where it needs to be. And it is my understanding that the substance of your bill is identical to the substance of Representative Blackman's bill, and so this committee looked very favorably, as well did the House of Representatives look very favorably on this bill. I think it's an extremely important bill to close the gap, and I hope that everybody on the committee supports this.
Thank you.
Ms. Kendrick.
Thank you. Could you answer if my line cut off, lines 26 through 29 were in the version of the bill that we passed, the 1 to 5?
I can actually probably best address that. The version, the only wording difference between Representative Blackman's bill and this bill is they're placed in different code sections. This bill is in 16-11-91, and Representative Blackman's bill was placed into a different part of that code section. And the part where Representative Blackman's bill is, there's a series of bills that all point to one sentencing provision, so the individual sentencing provisions are not found in the bill. For example, Representative Blackman's bill didn't have the sentencing provision, but it is referenced in the same code section that his bill was filed in. This bill, this is, somebody correct me if I'm mistaken, the sentencing provisions are stated out in this bill because of the code section it was filed in. It didn't point to another sentencing code section, but it is the same sentence that Representative Blackman's bill carried. So, does that make sense?
It does.
Ms. Dickerson.
I pass. Thank you.
Ms. Ballinger. Dr. Price.
Yes, I just had a question regarding the penalty, which is significant. And if a person, and I think we all remember someone doing this in high school, of course they would be probably considered a juvenile, but, sticking the old mirror on the shoe, it was pretty abhorrent, but just the same, I would hate to see that person go to jail for a year, and that's a mandatory sentence, is it not?
No, it's not. The sentence is 1 to 5 years. All of that could be on probation, though. So the minimum sentence would be 1 year on probation would be the minimum legal sentence. The maximum legal sentence would be 5 years in custody. But again, understand the range.
Okay, thank you very much.
Mr. Setzler.
And Mr. Chairman, also to Ms. Price, we think about the circumstance of a mirror on a shoe. This also contemplates using technology to look through someone's clothes. You've got thermals that can look through clothes and do things that were not possible when many of us were in high school. So this is more broad than just a mirror. And if you look on line 20 of the bill, underneath or through such individual's clothing. So you could imagine a scheme where somebody was setting this up in a place and doing it to masses of people. So you've got the ability for a much more serious circumstance than just a mirror on a shoe. And because of that, I think the 5 years is certainly, there are fact patterns where that would be more than appropriate, I would submit.
My point being, though, that it does include the mirror on a shoe.
It does.
Any further questions for the author? Seeing none, what's the pleasure of the committee?
Move to pass.
Vice Chair moves due pass of SB 45 LC. Let me I'll take that back. It's a do pass by substitute. However, we're gonna have a different LC number on 45. Is that correct? Because we're missing the 01? Okay, that's fine. I just want to make that clear for the record, such as it is. That it will be do pass by substitute. It will be a different LC number, but it'll be reflective of the text that you see in LC 297543S. Just want to make that clear. There's a do pass by the vice chair, a second by Ms. Ballinger. Is that right? Are there any amendments? Seeing none, any further discussion, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it, the motion is adopted. Thank you, Senator Walker.
Thank you very much.
We'll call Senate Bill 160. Senator Harper. And Senator Kirk. And while they're coming up to the table, let me recognize who's probably the judge of the week, or he's just here for recreational purposes, Judge Lawton Stevens. Thank you very much for being here, and thank you for being a resource to the committee. We appreciate it very much, and thank you for your service to the state.
Thank you, Mr. Chairman.
So, stand by for one moment.
Okay.
I just wanted to get it clear with the vice chair. What's going to happen, senators, is the vice chair is going to go ahead and speak to the changes that we've had with the context of in the context of the subcommittee meeting and the issues that were addressed there, and also the issues that arose there but were not necessarily dealt with there. I think y'all are aware of that, and I just want to make sure it's clear between us and certainly from members of the committee. I'll call on the vice chair to lay that out for us.
Thank you, Mr. Chairman. And I guess if everyone on the committee can reference the amendment is what I intend to walk through, which is AM 292613. And the LC of the underlying bill is LC 297570S. And so I'm going to use the amendment to reference the bill to walk through the changes that have happened between subcommittee and now, much of which centered around a discussion that was held at the last hearing on this. So if everybody is looking at the amendment, line number 4 is simply a cross-reference that had to be added into section 1 of the bill. So that's very simple. If you want to move on in the bill to page 5. In page 5, the part 3, section 3.1, what we have done is we have created a new definition of the concept of public safety officer. And so we've used many other, or several different types of jobs, essentially, that fall under the contemplation of a public safety officer other than just a peace officer or a correctional officer. And so the discussion point last time, Representative Trammell raised a very excellent point if you go down to number 7, to officer of the court. And this is essentially a copy and paste from a different code section in the aggravated assault statute where officer of the court is defined, and it includes the terms that you would think of in the context of being in court. And it also includes community supervision officer, county or Department of Juvenile Justice, juvenile probation officer, or probation officer serving pursuant to Article 6842. And so what it was contemplated through the discussion was that although defining officer of the court is appropriate, parsing out these probation officers into their own separate definition and then including that as a part of the public safety officer definition was the more appropriate way. So what you have in the amendment in lines 6 through 13, as you can see in line 6, officer of the court includes judge, attorney, clerk of court, etc. It stops when we get to these probation officer type things. And then the very next, number 8, probation officer, we've moved those 3 down into its own definition. And then you further look down in line 11 at number 9, the new definition of public safety officer. means, and then it captures several of the definitions in the bill. It excludes officer of the court, but it adds probation officer. Officer of the court and those that are classified in that are still covered in an existing law in aggravated assault, where there's an elevated penalty for an aggravated assault committed upon them, but they are not going to be considered or contemplated in this broader definition of public safety officer. And so then if you look down at line number 14, that's just simply renumbering because we've added a new definition in. So then moving on to line 15 in the amendment, that takes us into the aggravated assault. That's simply, again, a relettering. Section J is now Section K because of some of these changes. Moving on down in the amendment to lines 16 through 21, these are some substantive changes to the aggravated assault section that we contemplated and discussed in committee. The of significance, there's different types of aggravated assaults on a public safety officer. The first involves the discharge of a firearm, and that is found in the bill in line 181 through 188. So again, we're on page 6 of the bill, and that's the bill that Representative or Chairman Alan Powell had passed through the House of Representatives, which has been moved into this. In the hearing last week, we amended that to include the language that would allow the prosecutor and defense attorney to deviate from the mandatory minimum upon mutual agreement, and that is reflected in the substitute bill. Moving down to B, which is in line 189, this is the second tier of aggravated assault on a public safety officer. And so what the bill had originally used was an assault with anything other than one's hands, and also not a firearm, because a firearm is included in A. So an assault with essentially an object, device, or instrument, which when used offensively against another may cause serious bodily injury. That is what Section B contemplates, but we had previously drawn out or excluded the concept of using one's hands, but it was discussed in a committee that what if somebody elbowed an officer or kneed an officer or kicked an officer, which of course none of which is appropriate behavior, but in order to draw a line between kind of the vagueness of the idea of hands and to make it consistent with other actions similar to the hands, we have replaced the word body. So if you look in line 22 on the amendment, you see the word hands has been replaced by body, and that's also found in above in the amendment specifically to B. So we've replaced hands with body. The other thing that we have done in this code section is we have stated that you have to be, in order for the mandatory, there's a 3-year mandatory minimum that is connected with this offense, with the offense described in B. You have to be at least 17 years of age in order for that mandatory minimum to apply, meaning that if a juvenile is transferred to Superior Court via the petitioning process, which would be what would be required pursuant to B, then if that were to ever happen, they would not be subject to a mandatory minimum that you would have to be 17 or older. You'd have to be able to be charged as an adult. Moving along to the next page, lines 200 through 207. This is Senator Kirk's portion of, part of his portion of this bill, of Senate Bill 160, is concepts that he had in what he had previously passed to the Senate as Senate Bill 154. And this deals with trying to figure out how to take fine money from defendants who are convicted of these assaults or aggravated batteries, or obstructions on police officers, and how to essentially earmark a portion of that fine money so that it goes to certain dedicated things. So what we have settled on, or what we have done, is if you go to line 23 of the amendment, then what, this line 23 through 30 essentially replaces 200 through 207 in the bill. And we have limited that to being able to, that extra fine money, once the other surcharges come out, will be paid to the Georgia State Indemnification Fund. So I've done a lot of work on this. In fact, and somebody's here from Department of Administrative Services, but there's an entire code section in Title 45 that deals with the indemnification fund. And through hours of work, we're finally able to get to the bottom of this, and it is codified that the fund, which is administered by the Department of Administrative Services, is authorized to accept deposit from other sources other than appropriation for that fund. And so my whole goal with this was to make sure this was a great idea, and it came from a great place, but what the time I spent in this was making sure that we got this right so that it would actually get where it needed to go and that it would be used for that purpose. And working with Legislative Counsel and everybody else, we feel comfortable with that. So that is the way this fine mechanism is going to work now. Moving on down to the amendment, line 31 through 35. Again, earlier we said that we had changed the definition of officer of the court back in a few pages earlier when we were defining things. But since we excluded officer of the court from this new public safety officer definition, then we are restoring the current language in aggravated assault that creates the elevated sentencing for committing an aggravated assault upon an officer of the court. So again, that would be a sentence of 5 to 20, but that 5 years can be probated, so there's no mandatory minimum of any time in that. Moving on down to lines 36 through 38 in the amendment. Now we're in the aggravated battery section of the bill, and this goes back to we had, in the juvenile concept that this committee has heard through House Bill 116, which I carried through the House and has been essentially adopted into Senate Bill 160, we've been very conscious of making sure that we are not subjecting any potential juveniles who are transferred to Superior Court via the petitioning process or the direct process that is contained in Section 1 of this bill, which is for committing aggravated assault with a firearm upon a public safety officer or an aggravated battery. We have added in the language underlined in line 37, provided, however, that for persons who are at least 17 years of age, and if you read that in context with the main bill, then what that does is that essentially, in order for the mandatory minimum to apply, you have to be 17 years or older. So it's the same thing that we had just spoke of a minute or two ago with aggravated assault. So that anybody who's under 17 will not be subject to said mandatory minimum. Finally, or getting very close to the end, lines 39 through 42, we had, so now we're in the obstruction section of the bill, and if anybody's still following along with the bill, we're on page 11. In line 352, which is section C, and this is a new portion of the obstruction code, and this is to offer a specific crime to protect a range of officers who are typically in the incarceration, that work in jails and correctional facilities, it regards to them being subjected to human or animal blood, urine, feces, vomit, or seminal fluid. There was some discussion about how the structure of this code section was, and that while in line 352 we say that you have to willfully resist, obstruct, or oppose, but then in line 356, by causing or attempting to cause, which created some confusion, is that language modifying the intent in line 352? So what we did was we replaced lines 356 through 360 with the language that you see. We simplified it. We also removed this whole causing or attempt to cause language so that that's no longer there. And we replaced that with this more simple language, which I believe achieves the goal that we were hoping for. The last thing is that the very last part of the amendment, lines 43 through 51, the same concept of the fine in aggravated assault and aggravated battery, the minimum fine is at least $2,000. We have also added this concept to obstruction, but the minimum fine is at least $300, with the same language that will send portions of this to the indemnity fund. And so that is how the amendment works with the bill. And myself or either the senators, I believe, probably would stand for questions.
Questions for the subcommittee chair or for the authors? Ms. Kendrick.
Thank you, Mr. Chair. So lines on the amendment, line 17 through 21, the language is a little confusing, so I'm trying to understand if the range is from 5 to 20 years, why do you have to put in line 20 and 21 that says the mandatory minimum is 3 years, and it might just be
The current, I can definitely explain. Current law is an aggravated assault upon a peace officer, correctional officer. The range is 5 to 20 years, and that is still the range. The minimum sentence that can be given is 5 years. Now the question is, of that sentence, what of it can permissibly be given as probation versus incarceration? So the way that this concept reads in Section B is that you would receive a minimum sentence. The minimum sentence you could receive if you're 17 or older and you violate B is a 5-year sentence with 3 to serve. And you would be eligible for parole. It is not a non-parolable issue, but that would be the minimum. The maximum sentence would be 20 years to serve, or you could receive 20 years of probation with 3 years to serve, or you could receive 10 years of probation with 5 years to serve. But for purposes of what I think your question is, the minimum sentence would be 5 years with 3 to serve, and you would be eligible for parole.
Mr. Sessler.
Thank you, Mr. Chairman. I'm looking on the amendment, page 2, lines 40 through 42, again, of the proposed amendment. I'm comparing that language to lines 356 through 360 of the bill. I know there was some discussion about knowingly and willfully resists, but then on line in the underlying bill, my concern is we need on line 40 of the amendment to put knowingly and willfully in front of throwing and projecting or expelling. As I read the amendment, without knowingly and willfully, somebody could vomit, someone could expel vomit on a police officer, know they're vomiting on a police officer, but unless it was a willful vomiting on the police officer, it becomes a felony for barfing on a cop. And I think knowingly and willfully being added again on line 40 of the amendment would mirror what's above on line 352 of the bill. Does that make sense to the author?
I would defer to legislative counsel.
I forgot about the shoe vomit when we were crafting this. Probably right.
Okay. Okay.
That was just, and as we're looking at this, that was just something I noticed. I unfortunately could name people in my hometown who vomited on a police officer, and that was not a pretty era of their life, but I don't think it's a felony. And I appreciate that consideration. I had a question also for when we remove officer of the court. I'm very comfortable not having, and I say this tongue-in-cheek, attorneys having the same protection that police officers do. I do. My question, though, is when we remove judge, I mean, to me, when I think about lawless countries, around the world, what's the most heinous crime is their whole judicial system is racked by judges getting death threats and those kind of things and threats on judges. I just raised the question. I'm glad we're protecting EMTs, but judges, I see them as maybe being in a little bit different place than attorneys. And
Well, and I don't disagree at all. I think that what we went back to looking at this was the boots on the ground law enforcement. And current law does give the judges are in the 5 to 20 range, and therefore, if aggravated assault was committed upon a judge, then whoever the sentencing judge would be on that person, if convicted, has the ability to, sentence accordingly. I don't disagree what you're saying, but in trying to keep the main thing, with this definition, those parts of the definition, with no disrespect to any of the folks that are included in officers of the court, but as a bit of an outlier from, I believe, the rest of the jobs, essentially, or professions that are contemplated in that. And so that was the main reason why we decided to do that.
Can I ask one further question? Sure. And I raised that as a policy question. It's just a pure policy issue. But I would also ask, again, the author's intent on lines 18 of the bill, and forgive me just for looking at the amendment here today.
18 of the amendment?
Yes, sir.
Okay.
And I know there was discussion about the not limiting the striking surface, as it were, to a hand, but it could be a headbutt, could be a kick, could be a knee or something like that. Again, this is the time to get this right if we're going to do it. I should ask the question, if the assault involves the body of somebody, meaning it's a rush towards or something, courts that are far from where we are today, having been part of this discussion, is use of the body, is that going to be perceived as a charge? I.e., if you're charging somebody physically, is that going to be perceived as, well, he charged the officer, therefore it kicks this in? I think your intention is using a hand or a headbutt or a kick or a knee as a striking surface. I mean, is use of the person's body the right term to use? I know we've been wrestling with that back and forth. Is there what's your intention there?
I mean, the intention was to draw a clear distinction between, I think a very valid point was raised in trying to differentiate between why we're calling the use of hands one thing and then the use of an elbow or a knee another. I think that to me, conceptually, those are much more closely related than when we get into the concept of objects, hammers, baseball bats, whatever it may be, that can be used as an object, device, or instrument, which when used offensively against another may cause serious bodily injury. And so keep in mind that if the aggravated assault is committed upon a public safety officer with their body, then the range is 5 to 20. It's just not subject to that 3-year mandatory minimum.
I hear that. I guess I'm asking more of a technical question rather than a policy question. I know what you're trying to address. I guess is it more use of a part of the person's body as a striking surface? And I know it may seem like an academic point. I'm just trying to flesh out what we're maybe to say precisely what we mean.
The way you commit an aggravated assault is with the use of an object, device, or instrument, or a deadly weapon. In this case, a firearm is already accounted for in A. So it's the use of an object, device, or instrument. So
should it be involve only the use of a part of the person's body? And I just say that none of these are hostile amendments. I'm just trying to flesh out, if you use a body part as opposed to someone's body, what does it mean to use my body? Maybe we could be a little more precise as we chew on this.
The limb. I mean, my intention is that the use of the word body is to be interpreted that the limbs and, as you said, headbutt, elbows, hands, knees, kicks, those very well may be serious offenses, but in trying to draw the line as far as what we previously had with hands, yeah, I mean, I think the entire body is, in my opinion, the best way to include all of that.
I mean, we're not qualifying with, whole body or entire body. When you put the word body in there, it includes a part of a body.
But so I guess what I'm asking is, if a person rushed at a police officer, charged them, didn't touch them, but charged at them, say the officer ducks into another room, or the officer, the person doesn't, the officer tackles them, whatever happens, is someone charging at an officer? I just want to be clear. It would be the policy of this committee, if someone charges a police officer, they're going to get a mandatory minimum of 3 years. Is that your purpose?
No, I believe that what this stands for is the opposite of that.
The mandatory would only apply if you did not use a part of your body.
That's right.
Mandatory does not apply to using part of your body.
You would have to use...
and that's what this is trying to clarify,
Right.
is to say that if you do not use a part of your body, the mandatory applies. However, if you use a part of your body, it reverts back to what current law is, and that's 5 to 20.
That's right.
Right, but is this, in this line 17 through 21 of the bill says if you're 17 years of age, you don't fire, you don't discharge a firearm, and it does not involve the use of your body,
That's right.
Mm-hmm.
there shall be a mandatory minimum of 3 years.
So a knife, a baseball bat, a object, device, or instrument.
Okay.
That is what triggers that.
So as it's used here, is the person's body is broader, and you're trying to have a broader.
That's correct.
Okay,
Under the bill we had in subcommittee, it was just hands, and I can't remember who brought up the point, and it may have been you, of kicking somebody. Under the way it was drafted, kicking somebody fell under the mandatory minimum. So
And we didn't
the
intend
language
that.
is intended that kicking someone is not considered under the minimum. It would revert back to the original of 5 to 20.
I see the construction. It's broader than.
Yeah.
Okay.
Mr. Trammell.
Thank you, Mr. Chairman, and I want to thank Chairman Reeves for his hard work in the amendment, which I'm supportive of. Just want to raise one question, policy question for the committee and for the authors. It involves the inclusion of correctional officers in the concept of public safety. And the concern I have is that, particularly with the aggravated battery section, that in confinement situations where inmates are often involved in altercations or fights, that we may be in the position of placing sentencing courts and handcuffing them to mandatory minimums in fights where truly there's not a clear picture of the facts. The sentencing provisions don't really serve a deterrent effect, and that we inadvertently get caught in just spiraling and tacking on to these sentences by people who just honestly got caught up in a bad situation. I would welcome comment on that.
And your comment is appreciated and understood. If I may respond, meeting the burden of the elements of aggravated battery is extremely high. Not only do you have intent, but you have the element of malice, which is a greater element to prove in court. And then there has to be serious disfigurement, dismemberment, or there's one other. I'm pretty good at this stuff, but I'm not drawing the third thing. But it's quite the burden to prove aggravated battery. I think that a fist fight, short of somebody's bone being broken or somebody being stabbed or receiving that kind of injury, wouldn't qualify under the aggravated battery statute, just based on the high nature of the offense and what must be proven. So. Looks good.
Any further questions for the authors or the subcommittee chair from members of the committee? Council, do you have, do you want to express any concerns that you may have?
No, I think y'all have done a good job, other than maybe Chairman Sutler and others that might need to be
Yeah, we'll take that up in the form of an amendment in just a moment. Any further questions for the subcommittee chair or the authors? Seeing none, what's the pleasure of the committee? Mr. Strickland moves due pass of SB 160 by substitute LC 297570S. Are there any amendments, Mr. Reeves?
Yes, Mr. Chairman, I offer as an amendment what everybody has been looking at for the last 20 minutes, AM 292613, as an amendment to LC 297570S.
Mr. Reeves offers AM 292613 to the substitute to SB 160. Any discussion, Mr. Setzler?
Mr. Chairman, I'd like to offer a substitute motion that it would move the Reeves amendment with 2 words added on lines 40 of the amendment, simply between the words knowingly throwing, subject to the veto of council, I would say knowingly and willfully. I would add the words and willfully between knowingly and throwing, so that there's that same willful element that's contemplated up on line 352 would be carried over here.
Mr. Setzler is moving an amendment to the amendment on line 40 of the Reeves amendment between the words, after the word knowingly, inserting the words and willfully. Comment, Mr. Reeves?
It's a friendly amendment, and I believe we should vote that amendment.
Okay. Mr. Setzler, any further discussion on the Setzler amendment to the Reeves amendment? Mr. Bodie?
And this may not be for, Mr. Chairman, maybe for Legislative Council. Is it a big difference between willfully and voluntarily in this situation? Because in my mind, I'm thinking willfully you can have a willful action, but it may not be voluntarily. Like if it's an involuntary reaction at this point in time. So I don't know if we need to add voluntary as well, or use voluntary in place of willfully. I'm just, it's my legal mind going spinning right now on that thought.
The term of art used consistently in the code is willfully.
Okay. Yes, ma'am.
Any further discussion on the Setzler amendment to the Reeves amendment? Seeing none, all in favor of the Setzler amendment of adding the words and willfully, inserting the words and willfully after knowingly on line 40 of the Reeves amendment. All those in favor of the Setzler amendment to the Reeves amendment signify by saying aye.
Aye.
Opposed? The ayes have it, and the amendment to the amendment is adopted. Are there any further amendments to the amendment? Seeing none, we'll call the question now, underlying question on the Reeves amendment as amended by the Setzler amendment, AM 292613. All in favor of the Reeves amendment signify by saying aye.
Aye.
Opposed? The ayes have it, the amendment is adopted. Are there any further amendments, Mr. Setzler? None? Are there any further amendments? Seeing none, on the underlying motion of due pass by substitute of SB 160 LC, well, it won't be 7570S, it'll just be by substitute of SB 160. On the underlying motion of due pass, all in favor say aye.
Aye.
Opposed? The ayes have it, and the motion is adopted. Thank you, Senators.
Thank you, Mr.
Thank
Chairman.
y'all.
Members of the committee, appreciate your help.
Yes, sir. Thank you.
Yes, sir.
Senator Rett, thank you for your patience. He's joined by Mr. Frank Rotundo. on behalf of the Georgia Association of Chiefs of Police. I got that right?
Yes, sir.
I got it right. Senator Rett, welcome. Thank you for your patience again. Senator Rett is here on SB 15.
Yes, sir, Mr. Chairman. Good afternoon. Thank you, everybody, fellow colleagues, friends, and y'all. We're here today to talk about Senate Bill 15. And what it does is it entitles retired disabled law enforcement officers to free weapons carry. Under the current law, retired law enforcement officers who have served at least 10 to 12 years immediately preceding their retirement are entitled to a free weapons carry license, provided that they comply with all the other requirements related to the issue. What this legislation does is what I propose is to provide that any person who has served as a law enforcement officer is entitled to be issued a free weapons carry license if, one, they've served at least 10 years, or they left if they left employment due to a disability that was sustained in the line of duty. Basically, I came up with this bill because I served in the military over 30 years, and a buddy of mine, we served together in the Air Force, and he retired and went into law enforcement. And he had to retire because of a disability. So we thought about it, and that's how we came up with this bill. And Frank here, he's been supporting me all along with this bill, helping me to craft it. It passed the Senate Judicial and the body of the Senate unanimously. And if you have any questions, Mr. Chair, we're
Mr. Rotundo, do you want to add to Senator Rett's comments?
No, sir, unless you have any questions of me.
Okay.
Thank you.
Let's get a report from the subcommittee. Chair, Mr. Setzler.
Thank you, Mr. Chairman. This bill substantively, I mean, it takes existing law that addresses this subject matter and then adds people who are, injured in the line of duty. Now, that's policy-wise what it does. There wasn't an awful lot of crafting in subcommittee, although we did read through it and spend some time with it. But it was a fairly straightforward policy question. And again, just broadening the people to those that unfortunately don't make it to retirement.
I think I saw a fiscal note on it. I think the amount was all about $32,000 or something like that. Was that right?
Yes, sir, that's for those who have retired in good standing, but for those who would retire with a disability, to be marginal at best.
Yeah, at
any
best.
change.
I just want to make sure there is a cost, but it is so
Marginal,
minimal.
right, yes, sir.
It's less than minimal on a $25 billion budget or more. Okay. Any questions for the author or the subcommittee chair from members of the committee? Seeing none, what's the pleasure of the committee? Move due pass of Senate Bill 15 LC 297389 SCS by Mr. Gravely, second by Mr. Trammell. Are there any amendments? Seeing none, any further discussion? All in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it, the motion is adopted. Thank you, Senator.
Thank you, Mr. Chairman.
Be sure to fill out the form in the Rules Committee.
Yes, sir.
Just to make sure you're aware of that, you have to fill out the form in Mr. Meadows' office.
Meadows? Yes, sir.
Meadows, yes.
I'll do that. Thank you, sir.
Yeah, in order for it to be on the consideration calendar Wednesday morning, right, at 9 o'clock.
Yes,
So make
sir.
sure you fill out that form today, so it'll be on the consideration calendar for the Wednesday Rules meeting.
Yes, sir, I'll take care of that
Okay.
right away.
Thank you very much for the bill.
Thank you.
Before I call on Senator Parent for her bill, let me just remind, I think we send out a save the date. We are, the committee, the Reeves Subcommittee and/or the full committee will meet tomorrow morning to consider two bills, to potentially consider two bills. One will be a committee substitute for Senate Bill 1. The other will be Senate Bill 154, which is originally authored by Senator Kirk. Senator Kirk has graciously given permission for the committee to use his bill as a shell for the committee to potentially consider a new substitute for what was House Bill 32 by Representative Chandler and Representative Turner, which was considered by this committee having to do with inappropriate teacher, school employee, sexual contact, and the penalties that go along with that. This committee considered that bill in the context of House Bill 32 and passed it out with a do pass recommendation. However, that particular substitute did not make it to the floor. Representatives Turner and Chandler may want to come forward with either with another substitute of some kind or more tomorrow for the committee's consideration using Senate Bill 154 as the vehicle as per the permission of Senator Kirk, which he graciously has agreed to do. I just want to give you a roadmap on that. Senate Bill 1 is being worked on as we speak. Frankly, we've got to see if we're in a position after this meeting to see if that substitute will be ready and ripe for consideration by the subcommittee or possibly by the full committee as a whole, given the late date. That's a determination that's got to be made, but I just wanted to give the full committee the full and exhaustive, if not exhausting, background of what we're doing, when we're doing it, and why, potentially. It's scheduled right now for 9:30. That could be a little bit earlier, depending, but we'll try to keep it to 9:30. It's okay. Okay. Well, given the preference, of course, is for subcommittee. Given the late date, we may push to full committee. That depends on the nature of exactly what it is and the breadth of what we're going to be considering.
Sequentially or in lieu of?
In lieu of. Yes, ma'am. As soon as I can get it done this afternoon.
Thank you.
Definitely by the close of business today. We like to do it. We always can't do 24 hours. We try to, but if we can't do 24 hours, definitely the night before. Okay. Senator Parent, thank you for your time and your patience.
Mr. Chairman,
Welcome.
if it's all right with you, I'll bring Mr. Spahas up with me as I did in the subcommittee.
Only on a probationary
That's right. If you
probationary status that can be revoked anytime.
Yeah, fair enough, Mr. Chairman. Chairman Golick and members of the committee, thank you so much for hearing SB 99. I'll try to keep this brief. This is a bill that fixes a simple problem. Right now, when someone is involuntarily committed to a mental institution for having been found a danger to themselves or others, their name is placed on the federal background check database, and they are unable to purchase a firearm. Here in Georgia, after 5 years, we automatically purge the names off the background check list. We don't do any sort of investigation as to whether or not those individuals are still subject to the disability that caused them to be involuntarily committed to begin with. To be clear, these are individuals who have been found by a doctor both to be a danger to themselves or others and to have been diagnosed with a condition requiring treatment, a severe one such as schizophrenia. Some individuals, in fact, perhaps many, deserve to get their gun rights back after successful treatment, and this legislation shortens the time before they can get them back by years. Under this legislation, an individual would be able to begin petitioning after release, and if the court did not find that they yet were relieved of their disability, they would wait 1 year, and then they would be able to apply again after a year. Right now, there's no mechanism in the law for anyone to apply. We just go straight to the automatic purge at 5 years. So, and of course, some of the individuals may still be suffering from the mental illness and should still be subject to the disability under law. The bill puts in place a hearing process whereby the court would assess the mental health of the individual in the same manner that they did before they were involuntarily committed. We are the only state that automatically purges these names off of the NICS, Federal Instant Background Check database, and we're also missing out on federal grant money that comes with putting into place a hearing process whereby individuals can be released from the disability. The change in here from the Senate is that the version that passed the Senate had a sort of second it was written as a second automatic hearing at 5 years, but it put the onus on the Georgia Bureau of Investigation to maintain a separate database that would then notify every individual that 5 years was up, and the GBI does not have that capability. So Nellie Miles, I believe, is still here if you have any questions about that. This probably sounds familiar to all of you, of course, those of you on subcommittee, but the rest of you too, because a version of this passed in 292. And as a matter of fact, a version of this exact same bill passed last year, both out of the Senate and out of the House, but then it was put in 1060, which ended up being the omnibus gun legislation that the governor then vetoed due to separate concerns. Right now, in 292, this segment is coming out because we are addressing it in this legislation, if that makes sense. So there's not a duplicate process. But if it sounds familiar, it's because you've already voted for it twice. And this bill, I think it just makes a whole lot of sense. It's more pro-gun rights than what we have in existing law, because if you're relieved of the disability, you can go ahead and get that ability back. If you, and it's pro-public safety, because if someone still is a danger to themselves or others, we would know that, and we would want them to be able to get well before they were able to go acquire a new weapon. Happy to answer any questions now, or if you want to hear from Mr. Spejas, and then we could both answer them.
Mr. Spejas, do you want to add?
No, Mr. Chairman, for fear of revocation of my privilege to be here, I will sit mute and answer questions.
No, I mean, if there is an interest on the part of the prosecutors in this type of issue.
This is a well-written bill. This is actually better written than what we had last year. We've learned a little bit more through the process and found that there were certain criteria in the hearing process that the federal government required to be there that actually wasn't in the bill that we passed last year. So we've cleaned that up. This is a better version. This is well-written, and it's a good public safety bill.
It also has, you'll see, I apologize, Mr. Chairman, for interrupting, but it does have this knife language that should be familiar to all of you. The reason we added this in the Senate, the reason we have it here is as this little change, because in the Senate we forgot to cross out 5. We just added 12. So that's why it's.
And where are you right now?
I am
What line are
on line 23.
Okay. Okay. Let me get a report from the subcommittee, Mr. Setzler.
Thank you, Mr. Chairman. Again, we took this up in subcommittee and really kind of went through in a little bit more detail. In essence, if someone's petitioning to get their rights back, this, as Senator Parent said, a little bit more detail in subcommittee, it gives them extra bites and more frequent bites at the apple, which, again, there's more chances to kind of be reconsidered, which we thought was an important piece. I would say, and I haven't had a chance to tell Senator Parent this, there's probably a 0.001 chance there could be some concern. I would say there's some national attorneys looking at this who have not read the change that we've got that's been made since the Senate. They said, hey, they may have there's no specific tweak, there's no specific concern. They just said until they've gone through and poured through every letter of this, they'd not had a chance to review the changes that have been made since the Senate. So they kind of held up, hey, there may be a concern we bring to you in a day or so. They're working as quickly as they can. I would just share that. That doesn't cause me great concern. I just want to put the committee on notice. There could be some little tweak that might be needed that we're not aware of with respect to how this folds into federal law and U.S. code. It's something we struggle to understand the way it feeds into federal code. But our subcommittee felt very comfortable with this.
But does it matter? Is it mirror 292? That's
This is
That's
actually,
Chairman. Is that Jaspers's bill?
It is. As alluded to by Chairman Setzler, it actually allows more bites at the apple than 292 does, because under 292 you can't petition for a year, and then you can only petition every 2 years. And under this, you could petition basically right away, and then every 1 year.
I will say this, as far as the changes are concerned related to the national model and what we're supposed to use as that model, none of that has changed since it left the Senate. I know they would have a hard time seeing that, but we've been here through this process, so the part that was signed off on by the attorneys that practice in this area has not changed.
That's my belief, Mr. Chairman. It's not been through that vetting, so for whatever that means, 0.001% chance there's even a concern.
Right, we did add that involuntary. We discussed that in detail at subcommittee to make it clear that it's just, we repeated it. That's the way it was before, but to be very clear, we repeated involuntarily hospitalized at an appropriate place to make clear that's the population we're discussing. And then Legislative Council did some great work on this kind of before session even started to improve on the bill from last year and make it line up better with the procedures that were also listed in 292.
Ms. Silcox.
Yes, I was just curious.
What kind of federal money are we missing out on?
I think it's about, theoretically, it would be about $700,000.
Any further questions for the author or members of the committee? What's the pleasure of the committee? Mr. Trammell moves due pass of SB 99 by substitute LC 411172S, second by Ms. Silcox. I'm sorry. Dr. Price, did you have something? Or Ms. Trammell? Somebody's light is.
Yes, it's mine.
Oh.
Thank you, Mr. Chairman. I'm kind of struggling with all these exceptions and where it refers to other code sections, but something that Senator Parent mentioned about, someone who's, for example, a schizophrenic who's under treatment, and I was just trying to find what you were referring to, but, I'm concerned about somebody who's treated as a treated schizophrenic and it appears very normal and would seem to be normal and could be released as normal. Obviously, if they don't take their drugs, they're not normal anymore because you don't get a cure necessarily.
Correct.
I mean, you get a mollifying of the symptoms. So that was troubling me. So I was trying to figure out what in here has changed.
Oh, that hasn't.
Nothing. Okay.
No, and you are absolutely correct, Representative Price. If the point of it would be if someone was not, say, taking their medication and having sort of florid symptoms that made them a danger, then they would not come off the list. Whereas if they had that in the past, but were taking their medicines and were functioning fine, then they should come off the list.
Well, I disagree with that because just because they're on medications doesn't mean they're always going to be on the medications. And many, many people lose the access to the medications and therefore come off them or to get tired of them or to get tired of the side effects and on, and then they have breakthrough symptoms and activities. So I'm still trying to figure out where this addresses that specifically.
If I could.
Go ahead. Yeah. Well.
What this system anticipates is, first of all, they have to petition under this. Then they've got to waive rights to certain records that would be admissible. And quite frankly, I think what this anticipates is an opinion from the treating physician. Because I think if the treating physician is still not supportive of an individual getting it back, the court could clearly not grant it back. And under current law, right now, regardless of what changes, at the end of 5 years, they just drop off the list. So.
Okay, and then I am a little concerned about the term involuntarily, because you could be voluntarily hospitalized, and
it only applies statutorily to involuntary
Right.
hospitalization.
So it's assessment by. I can discuss it more with you, but there's several checks in there. The doctors have to find that you are a danger to yourself or others. Then you go into the treatment center. You're evaluated by the probate court. The opinions come from the medical professionals. And only then, and even then, if you said, I will voluntarily accede to treatment at the institution, then you still wouldn't be barred. It would only be if you involuntarily were had to be found to be a danger to yourself or others. And it would really be in the current situation of where that person is. To your point about people can fluctuate. If at the time you're presenting to the probate court, that would be the relevant time of the inquiry for the hearing.
okay, my question, was only if is voluntarily, do we have a lesser standard?
You're just not barred.
You're just not barred.
Not
That's
barred at all.
Okay, thank you.
Mr. Sessler.
Sure. There is something that has caught my attention since subcommittee, and I did not raise this in subcommittee, so I'll say that. On line 99 of the bill, really 98 and 99, it's the court's duty to make hospitalization and treatment records confidential. It says on line 99, to the extent possible. We normally see language that references HIPAA requirements, or that is sort of the coin of the realm with respect to medical data privacy. I don't know if Ms. Miles from GBI could speak that. To the extent possible was something that I feel like we should have addressed in subcommittee but did not. Is there a reason that it's that broad?
well, the court's got to have the ability to do something with it, with the material, at least for the making of this finding. So I think what this anticipates, this is during the process. So in other words, this is a direction to the court to not release any more of that information that is necessary. But if we're in an open adversarial hearing and this is the relevant issue before the court, then some of that's going to be vetted publicly. But if you go on down lower, you understand that when this is all done at the end, like at line 118, I think that's where it's at, the records become closed and exempt from open records after this is over with. So this is just, during the process, this is a direction to the court to try to minimize the exposure of that information, but some of it's got to come out, and you're leaving the discretion to the court to determine what comes out and what does not.
Right, and if I can follow up on that real quick, if you go down to 126, it specifies that you can't use that information in any other type proceeding involving the petitioner.
I hear you. I'm just real sensitive to, governmental entities don't have a personal interest, don't have an institutional interest for privacy. If we don't lock down what this means, I don't know. I mean, I personally, this is how we wrestle with these things, to the maximum extent possible, the extent possible. What duty does, to the extent possible, really put on a court to maintain a level of discretion of someone's personal medical information? Because that's what's happening. I mean, you're literally letting someone's deeply personal medical information just fly out there in open court. And
sure,
how could that be buttoned down by saying the maximum extent possible? Or are there other proceedings that are analogous to this in the courts where there's this kind of information is thrown around that has a procedure that's tighter and a little more controlled?
Well, I mean, this type of procedure happens all the time on the front end, right? So I don't know, Mark, do you want to? I don't know if you can offer anything, but okay. If you don't mind, Mr. Chairman, sure. Mr. Middleton represents the probate judges, who are the ones who do these proceedings. So
it's the chair's pleasure.
Thank you, Mr. Chairman. Mark Middleton here on behalf of the Council of Probate Judges. To your question, there are specific code sections that relate to how these documents are handled in, as Senator Parent said, at the front end, when a person comes in and there is an involuntary proceeding, these very same documents are before the court at that point. So we could go back and review those code sections, or you could reference those code sections. I jotted a couple of them down here, but it'd be worth going back and taking a look at those and seeing if that would satisfy you. But the court has an obligation on the front end for sure, and I guess you could reasonably read to the extent possible to be consistent with those previous code sections.
And Mr. Chairman, I'm not contemplating making up new law here on the fly. I do think if there's something that provides a level of certainty and safety, that I guess one could say it already applies. This was something that was not addressed in subcommittee that I just was a little nervous about. I don't see, to the extent possible, as a governmental duty for privacy interest being used very much.
I mean, I think it's just a policy issue. I mean, this issue gets dealt with in the criminal realm as well, where these records are used in an open forum. I mean, you got to remember, you've got a petitioner here that has asked to come off of this and has volunteered to give their records up. This is, I would caution you against you taking it out, because I think it does make a good policy statement that don't put any more of it out there than is necessary, and you're giving the judge that authority to say what that is. So there's going to be things that are in that file that the judge is going to deem not relevant to the proceeding that I won't have, for instance, access to, or the petitioner in the original petition. So I think it is a policy statement to give the court some direction that it should be protected to the extent possible.
right, and in addition, this does, as we discussed, contemplate a de novo appeal. So some of that information will have to, by necessity, go up to the appellate court.
Okay. And Mr. Chairman, if I just would ask members of the committee, since we're working on a sub anyway, it's not the same version the Senate passed. I mean, is it helpful to say to the maximum extent possible to demonstrate there is a duty for the court to try to protect it? I don't.
Yeah, I think we've replicated it from somewhere else.
I just wanted to raise that. That was not debated in subcommittee. It was a concern of mine.
Okay. Any further questions or comments from members of the committee? We actually have a motion and a second on the table, on the floor, on the table. Already, are there any amendments? Any amendments on SB 99, Mr. Sessler?
Mr. Chair, I don't have a sense of the committee. I don't want to offer an amendment that's going to go down 8-1. I just, I just don't have any sense of to me, putting a duty on the court to protect it to the maximum extent possible. I mean, Ms. Silcox, who gives me great advice through these committee meetings often, says one is certainly putting their information out there themselves when they do this, but I do think that's different than courts sort of being able to willy-nilly really have no duty to be discreet about it. I raise that to the committee. I could phrase that in the term of an amendment, but I don't.
Well,
I don't
it's
have a
still,
sense
I
of the
mean,
committee.
the bottom line is it still gives it's more instructive to the court as opposed to a mandate. 'Cause at the end of the day, the court does still maintain discretion at
It's
the end
not
of
a
the day.
standard
So
that
it's
can be
more of
reviewed either way.
more of
Yeah.
a intent message than anything else.
And Mr. Chairman, it does say shall keep confidential to the extent possible. That's probably implied. I'll leave that alone. I raise that as a concern, Mr. Chairman.
Well, I don't see the harm in maximum because I just don't see it getting in the way of the court's discretion. Ultimately, I think it does send a clear message as to what the intent of the legislature is in that particular
At
section.
the urging of the
without
chair, I'll
tying
offer the
their hands.
amendment, Mr. Chairman.
But it's the gentleman's discretion. I don't see any harm in it personally, but I'm just speaking for me, So,
Mr. Chairman, I'd like to add the word maximum between the and extent on line 99.
Mr. Sessler offers on line 99 of the committee substitute on SB 99, after the word the, insert the word maximum. Any further discussion or questions or discussion on the amendment? Mr. Grabling.
Thank you, Mr. Chairman. Does the author of the bill see this as a friendly amendment?
I think it's superfluous, to be perfectly honest, but I'm not, I don't think it really changes it one way or another, to be honest with you, because it says the extent possible. I'm not sure what the difference is between the extent possible and the maximum extent possible. But I totally understand the chairman's, a little bit of trepidation about it, and again, I don't think it really.
Well, I think the first question is, first rule is do no harm, right?
You got it, Mr. Chairman.
And the question I have first is, does it do any harm?
I don't believe
That's
so,
just what
Mr.
I ask
Chairman.
myself. That doesn't
Right.
mean anyone else does. Ms. Kendrick.
That was my question is, how does the author feel about it?
Okay. All in favor of the Setzler amendment of inserting the word maximum after the word the on line 99, all in favor say aye. Aye. Opposed?
No.
All those in favor of the Setzler amendment signify by raising your hand. 1, 2, 3, 4. Opposed? And the amendment is adopted. Any further amendments? Oh, yeah. 118, council has pointed out, I think we have a typo on line 118 that I sure didn't catch. Line 81, you see 2.1A, and then on line 118, you see 2.3A. We're presuming that's supposed to be 2.2A.
Thank you.
So any objection to that? Am I missing anything on that? I don't think so. Any objection to making that a technical amendment? Hearing none. It's adopted. Any further amendments, technical or otherwise? On the underlying motion of do pass by substitute of SB 99, all in favor of the motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Senator Parent.
Thank you very much, Chairman and members of the committee.
Members, we'll get that notice out on tomorrow as soon as humanly possible. Thank you for your attendance here today.